I'm here. Hi, Mary.
So Tim and I are both presenting, and Tim McDonald is the managing partner at Arnold Porter, a large corporate law firm here in Denver. And I think that Tim has just picked up the screen share. Is that correct?
Yeah.
Okay. So
It's up and running. It's up and running.
You're under control. Thank you. And Tim and I are going to split the presentation sort of back and forth, and we might even interrupt each other and interject a few words here and there. But Tim and I are both fellows of the American College of Trial Lawyers. It is the preeminent organization for trial lawyers, that is, people who devote their practice to what goes on in the courtroom. The American College of Trial Lawyers, along with the National Association of Women Judges, put this program together. I'm sorry, I'm hearing someone. Is there a question?
If everybody would go on mute, please.
Okay, thank you. So we are here today to talk about the rule of law. And we are going to be respectful of your time and have a shortened presentation. We would welcome some questions at the end, depending on what time is available. And I hope, Fletcher, that maybe you have got a way to capture questions that we can gather and try to address them at the end.
Okay. If you would, you can put questions in the chat box. Okay.
So the National Association of Women Judges and the American College of Trial Lawyers put this program on the rule of law and impartiality of the judiciary together because we've really got an urgent need for the public to understand the importance of an independent judiciary. I was truly impressed with Myrna's invocation, as well as the Pledge of Allegiance that everyone recited, because those two things in many respects go to the heart of why the rule of law is so important. So let's go to the objectives. Tim, if we can, the presentation objectives, because here is just an outline of what we intend to talk about today, which is why the judiciary is different, why it is so important to have an independent judiciary, the difference between the judiciary, the executive branch, and the legislative branches, to evaluate the significance of the judicial branch, and to explore some urgent things that are affecting or the courts are facing now related to challenges to the impartiality of the judiciary. So let's go to really what is the rule of law. I think we've all heard that phrase so many times, and the concept of a rule of law comes from our Constitution. It really comes out of a Declaration of Independence and the establishment of the country. But the rule of law is what we as members of society in the United States have bought into, have accepted as the governing principles for our society. And so we are looking at the fact that the law applies to everyone. No one is above the law. All people and companies are to be treated equally under the law, and the judiciary must be impartial in looking at cases before any judge, so that it is the law and the facts that control the outcome of the case, not the whim or politics of any judge or politician. So when we look at the rule of law and what the law is, we're looking at the difference between state law and federal law. So Tim, if we can go to the next slide. This slide, I have to tell you, I think is a little misleading. While the Constitution of the United States certainly is the supreme law of the land, this slide suggests that federal law is more important or is superior to state law, which is not the case. The Constitution of the United States applies to any matters that are handled in federal courts. It applies to any matters that are handled in state courts. The state constitution applies to any matters that are handled in state court. And sometimes, depending on the case pending in a federal court, will apply there too. But if we get down to what looks like the bottom rung down here in local ordinances, this slide implies that local ordinances are on the bottom of the heap. But in fact, local ordinances, just like any state statutes, are as important and as enforceable as any state statute may be. What we really have is a parallel system. And I think we should go to the next slide, because we have got here really the distinction that we've got the federal courts and the state courts, which operate side by side. Matters that are handled in the federal court by a federal judge may be matters related to the United States Constitution. They may be related to federal statutes, but they also can relate to what we might think of as pretty ordinary state law contract claims if certain requirements are met so that the parties can get themselves into federal court. In the state court, sometimes even the state court is going to deal with some federal issues, but generally in the state court, we are dealing with state statutes, state-related disputes, the state constitution, of course. And these two jurisdictions, that is federal jurisdiction and state jurisdiction, really exist side by side. And just as an aside, lawyers often strategize about whether they would rather be in state court or in federal court for any particular case. And the federal courts, of course, will deal with criminal matters as well as civil matters. The state courts will deal with criminal matters as well as civil matters, which will also include domestic relations and juvenile issues and things of that sort. But we have parallel systems, and we have federal judges, and we have state court judges as well. So let's go to the next slide, because we need to look at the fact that the judicial branch is different from the legislative branch or the executive branch. The judicial branch is not supposed to be political. The judicial branch is supposed to be impartial and impose the rule of law on cases before it. Now, the jurisdiction for the judicial branches does come from the Constitution, the United States Constitution, as well as the Colorado Constitution and its statutes. The courts are there to protect the rights of individuals, and individuals also includes companies. I'm not making a distinction here between individual people, human beings, and companies, because both individuals and companies are to be treated equally before the law. So when we look at what the judicial branch does, we have got a list of things in this slide, Tim, which is the next one, which again, I think ought to be revised in terms of what's listed first. because the first thing that either the federal court or the state court does is to look at a case which is presented to it. That is, someone sues somebody else in state court or federal court and brings that matter before the court for resolution. In addition, the state itself or the federal government may bring criminal charges against an individual or a corporation and bring that before the court for resolution. Yes, sometimes courts are going to decide constitutional issues. Sometimes they are going to decide statutory issues. But for the most part, what the courts are doing is deciding a case that is presented for resolution to that particular court. So let's go to the next slide, Tim.
All right, thanks, Mary, and I will jump in here now. It's nice to meet all. Can you hear me?
Yes.
It's nice to meet all of you virtually, and thank you for having us. As Mary said, my name is Tim McDonald. I'm a partner at the law firm of Arnold and Porter here in Denver, Colorado, where I practiced law for 23 years. So the one question I think that maybe we learned back as elementary kids was, how is the judicial branch different from the other branches of government? So, and I'd like to talk a little bit about that. And the first, when we think about the legislative and executive branches, they're influenced by public opinion, obviously, and they're elected with respect to the executive, the president, a governor, a mayor, and as to the legislatures, both state and federal, they're elected by the people, and they are designed and intended to be influenced by the people. And of course, while our founders, some of them didn't think much of political parties, we've now lived with political parties for several hundred years, and our legislative and executive branches are heavily influenced by party politics today. They're influenced by lobbyists, by special interest groups, and by their own personal opinion as to matters of policy. And that's as it is designed to be. The legislative branch, the executive branch are political actors intended to be influenced by their own personal opinions, as well as the views and opinions of the public that elected them to those respective positions. Well, how's that different than the judicial branch? As Mary said, the judicial branch is intended to be fair and impartial. The personal opinion of a judge is not intended and shouldn't be the determinative outcome. It shouldn't be any part of an outcome of a case. It should not be, the decision of a case should not be influenced by public opinion, political pressure, special interests. And that, we think, is one of the sort of cornerstones of our democracy, what has kept us apart and made us a shining city on the hill, in our view, as lawyers and as trial lawyers, is that our judicial branch is independent and is outside of politics. And then the question arises, well, how should judges make their decisions? If it shouldn't be based on their personal opinion on an issue, if it shouldn't be based on the political whims of what is popular or unpopular in a given day or month or year or decade, what should judges make their decisions about? And here, the Constitution provides, both federal and state, that our decisions should be based on the law and the facts, and that a judge must be impartial in applying and interpreting the law. As Mary said, we have the United States Constitution, which is the supreme law of the land. So nothing that a judge does or or decides can be contrary to the Constitution of the United States. They also have to follow the state constitutions. They have to follow federal law, state law, municipal law, as well as case precedent. And of course, undoubtedly, all of you have followed public events, and following case precedent is an issue that's in our news quite a bit. And different judges actually have slightly different views about the binding nature of prior precedent. It's a doctrine called stare decisis, is the Latin word. But case precedent is the last piece about how judges need to make their decisions. And one issue that we'll talk a little bit about today is, how are judges accountable? And one is they take an oath of office. They swear to support, protect, and defend the United States Constitution if they're federal judges or state court judges, as well as the state constitution. As we talked about, the basis for decision is set out in statutes and constitutions and prior case precedent. And there's an appellate process. So whether it's a civil case or a criminal case, anyone who feels aggrieved, doesn't agree with the decision, can take that initial decision by a trial court and appeal it. And in many instances, they can appeal it again. So in Colorado, we have an intermediate court of appeals called the Colorado Court of Appeals. And if someone doesn't like a trial court decision, they can appeal there. And if they don't like that decision, they can appeal to the Colorado Supreme Court. So there are two levels of review in the state court system. And then depending on the issue, sometimes even a third level of review at the United States Supreme Court. And so that helps ensure judicial accountability. There's also a code of conduct that judges must follow. And that code of conduct is intended to ensure that our judges have the highest ethical standards, the highest moral conduct, and that they can be held account if their conduct does not abide by the code of conduct and through disciplinary actions. And that's handled at both the state and the federal level. Let me turn it back over to you, Mary.
So let's talk a little at this point about the courts and judges making difficult decisions. One of the things that judges are obligated to do is make very difficult decisions based upon the law and the facts. This is something that we read about often in any newspaper or hear about on TV or other internet news. We hear about judges having to make very difficult decisions, and they have to make those decisions in accordance with the provisions of the United States Constitution, the state constitution, and the statutes and precedents which may be applicable. I think for a moment back in history, some of us will remember, and others of us will simply recognize the case of Brown versus Board of Education. That was a decision in 1954, went to the United States Supreme Court, and a unanimous decision of the United States Supreme Court determined that segregated schools violated the Constitution of the United States. Accordingly, the city of Topeka had to change its practices, and many other jurisdictions, many other school districts across the country had to change their practices because segregated schools were not passing muster under the United States Constitution. And in 1954, you can imagine that this was an especially controversial decision that judges had to make based upon the facts and the law. Another one of the tough decisions, at the time tough decisions, was the subject of a recent movie called Loving. Perhaps some of you saw it. The case is Loving versus Virginia. the state of Virginia, that is, where the US Supreme Court in 1967 determined that a statute in the state of Virginia, which precluded, that is, disallowed interracial marriages, could not stand under the United States Constitution. Again, a very, very controversial decision at the time, in particular in the state of Virginia. But the judges looked at the facts and the law and decided that the Virginia statute could not stand. If we think about judges needing to set aside their personal beliefs, their political beliefs, things that might make them partial or put a thumb on the scales of justice in favor of an outcome that they would prefer as a person. We can think about a very controversial case, remains controversial, and that is Roe versus Wade. In that case, in the mid-1970s, the United States Supreme Court, of course, affirmed the right to choose, a woman's right to choose to terminate a pregnancy. And in that case, there was a Supreme Court justice, Justice Brennan, who was a practicing Catholic. He voted in favor of the majority decision in that case, which means that he was making a decision that he thought was in keeping with the law and the facts, regardless of the fact that his personal religion would dictate otherwise. So we have some enormous problems that the judiciary must face and deal with those matters in an impartial way. And the cases that I have identified are headliner cases. They really strike a nerve in many communities in the country. But we can think about many smaller matters. Let's look at a state court judge who may be determining boundary to property, two neighbors disputing the boundary between their property. If that judge had a financial interest or in real estate or was related to one of the parties, so that that judge was not making an impartial decision, we would realize that justice is not served when a judge is influenced by things other than a fair reading of the law and the facts. So we know that our judges are faced with difficult decisions day in and day out. And can we have the next slide, Tim? Because we're looking really at the fact that we've got majority opinions and we have got minority opinions. Individuals may have beliefs and opinions which are different than the prevailing majority view at the time. The courts are there to protect that minority view. In the introductory comments, I forget who it was who was talking about the Lions helping an individual family who is in tough straits and needs help. That individual family ought to be treated the same under the law as anyone else. And that requires judges to deal with the facts and the law and in an impartial manner. So the judiciary really is there to safeguard the rights of the little guy to have different opinions, to have different needs, and the court will protect those interests as long as they are supported by the Constitution and the statutes which may apply to any particular case. So let's go to the next slide, please, Tim. And the real point that we've been making and that Tim was making as well is that judges are not politicians. They're not supposed to be politicians. They are not supposed to be influenced by political matters. By social matters, they look at the law and the facts. And that makes them quite different than the legislative branch or the executive branch, which indeed are designed to look at those political and social issues and try to resolve them as best they can. What we have in the next slide is a quote from Chief Justice John Roberts. He is the Chief Justice of the United States Supreme Court. And what he is telling us here is, again, the basic point that judges, no matter how they come to the bench, that is, if they are appointed or if they are elected, makes no difference. Judges are to be impartial. They cannot be politicians. They cannot be influenced by political matters. They must act and apply the law without fear or favor. That is, they cannot play favorites for whatever reason. They cannot play favorites with the parties that are before them. They've got to apply the facts and the law. So with that, I'll turn it back to Tim.
Thank you, Mary. I'd like to talk a little bit about state courts. And as Mary said, the state court, the state court system runs in parallel to the federal court system. And state courts are where more than 90% of court cases across the United States are handled. And it's over 100 million cases are heard in the state courts. And that includes cases that impact every aspect of your daily life. So traffic court, family court, probate courts, civil cases, if you have a dispute with your neighbor or an employee or an employer, and criminal courts. And all those matters are handled in the state courts. And there are both trial courts where they may hear a civil or criminal or family law matter, and a jury can decide the factual issues. And as I said before, there are appellate courts. And one of the interesting things is how our state court judges become judges. And it's different across the country. And we'll talk a little bit more about how we do it here in Colorado, as well as how it's done in other states. So the primary methods of selecting judges, there's really three methods across the country. There are elections. Those can be both partisan or nonpartisan, depending on the state. There can be appointments by the governor, or sometimes a lesser official, a mayor perhaps. And there's hybrid models, merit selection and retention elections. And there can also be different models within a state, depending on the level of court. We in Colorado, in my view, are incredibly fortunate to have a merit selection system with what are called retention elections. And I'll talk a little bit more about our system. In my view, and I've tried cases across the country in states from Alaska to New York to Washington to Wyoming and Montana and California. I think we have the best system for selecting judges in the country. Now, there are other states that do it similar to Colorado, but I think it is the best method for doing the things that Mary and I are talking about, which is ensuring a fair and impartial judiciary. So let's look at the system across the country. You see the map there, and the light purple, which includes Colorado, many of the states in the Midwest and the West use what's called merit selection, or the Missouri Plan, because it emanated out of the state of Missouri in 1940. And all those light purple states generally have a judicial nominating commission. That's what we have here in the state of Colorado. The Judicial Nominating Commission is made up of both lawyers and non-lawyers. It's made up, at least for the highest level of courts, the Colorado Supreme Court and the Colorado Court of Appeals, from people across the state. It has to be two people from every congressional district. It has to be made up of people from every political stripe. It has to be evenly divided in thirds between Democrats, Republicans, and independents. And as I said, half lawyers and half non-lawyers. And so our judicial nominating commissions then sift through candidates who would like to be a judge for that particular level of court, and then interview candidates, go through a rigorous process, and eventually forward 3 names for a particular open judgeship to the governor. And the governor has a set amount of time, short amount of time, to pick one of those 3. And so it takes things out of traditional party politics and partisan politics and puts it in the hands of citizens, both lawyers and non-lawyers. If you see the light green on the map, those are states where they have nonpartisan elections, although in many of those states they become partisan elections, even though they're designed to be nonpartisan elections. The dark green are explicitly partisan elections. So you see that in Texas and Louisiana, Illinois, Alabama. So a few states that have expressly partisan elections. And then you have gubernatorial appointments. That's generally up in the Northeast. And then there's a few legislative appointments and some hybrid systems. So that's a look at the way they appoint state court judges across the country. I'd like to talk a little bit about other issues that are impacting the judicial branch.
Tim, can we talk about one thing before you get there?
Absolutely.
And that is that we haven't told you how federal court judges are get into their role. All federal court judges are appointed. They are appointed by the President of the United States, subject to approval by the Senate, so that someone who wants to be a federal district court judge in Colorado, for example, that person's name would be brought to the attention of the executive branch, generally through senators or representatives from the state of Colorado. And then a determination would be made by the executive branch about what name to put forth as a specific nomination. And then that individual would go before the Senate for affirmation. And sometimes they are not affirmed, but in most circumstances they are. Thanks.
Yeah, thank you. Thank you, Mary. That was an important point. One other piece that I didn't say about, or I didn't emphasize in Colorado and in most of the states that have the merit selection or Missouri plan, is voters do have a say in a retention election. And so once a state court, unlike the federal system where a judge is once appointed by the president and confirmed by the Senate, they serve for life unless they're impeached, which almost never happens for a sitting federal judge. They serve for life. And that's why we have Supreme Court judges that are in their 80s today. State court judges, on the other hand, they'll have a mandatory retirement age in the state of Colorado of 72, but there's also, they sit for retention. And depending on the level of judge, it can be every 6, 8, or 10 years. And it's simply an up or down vote. It's not a judge running against another judge, but it does allow the public the opportunity to vote a particular judge out. It doesn't happen very often in the state of Colorado, but it does happen from time to time. Many people, by the way, leave their ballots blank for those judges. And one of the reasons we're doing this presentation is to encourage folks to do their own research and evaluate, make their own evaluation. So other issues impacting the judicial branch. In 2019, there were a significant number of states that sought to limit the role or independence of the courts in their state. And this is a map of 25 different states that sought to reduce the power of the courts or the independence of the judiciary in 2019. 2020 was a similar year. And you know, those are the types of actions that concern those of us who care deeply about the rule of law and the independence of the judiciary. And what are ways in which legislators attempt to limit the role and independence of the court? One thing that some of the bills across the country have done is they seek to inject greater politics into the judicial selection process. So if there are decisions that are unpopular with a section of the public, they think, well, let's get rid of the merit selection process. Let's go back to a different system where politics can have a greater influence. A second thing that has happened around the country is legislators want to make it easier to remove judges so that they can be closer to the political whims or desires of the public. A third is to reduce judicial compensation, and this can only be done at the state court level because the federal constitution bars the reduction of compensation for federal judges while they are serving. So that's something that the founders recognized could be subject to political abuse, is you can go in and through the power of the purse and just cut their salaries. So it cannot be done at the federal level, but it can be done at least in certain states that don't have that protection. And some states have been trying to do that in recent years. Fourth legislative attempt around the country is to shorten judicial terms. So rather than have judges who sit for 6 or 7 or 10 years before a retention election or a partisan or nonpartisan election, they wanted to, some legislatures around the country have tried to propose shortening that. And a fifth proposed change in various states has been to restrict the power to declare certain laws unconstitutional. So from the founding, the outset of our republic, in a case called Marbury versus Madison, the first Chief Justice of the United States Supreme Court, John Marshall, issued a ruling that said it was the power of the Supreme Court and the court system, the judiciary, to declare what the law is and to declare whether or not a law does or does not comply with the Constitution. And some legislators don't like that, and they would like to have that power that if they pass a law, it is per se constitutional because they declared it so. And so there have been certain efforts to restrict the power of courts to do what they've done for the last 200 plus years, which is evaluate the constitutionality of state statutes. And in North Carolina, this is an interesting aside, they proposed a constitutional amendment to alter the selection process for judges, and that was defeated by the voters. So a sort of final question to leave your group, the Lions Club, with is, what can you do? And one thing you can do is be informed. Learn about the system, like presentations like this and your own research, and you know, make sure that you understand how things work in Colorado for the judiciary, both at the state and federal level. Then use your voice, vote, educate yourself. There's something that is put out about each and every judge by an independent judicial commission evaluating the performance of every state court judge before every election. A huge amount of time and effort is put into that. That blue book is available online for every voter to review before they make their selection for state court judges, and we encourage you all to educate yourself and be an informed voter.
Let me throw in a couple of additional comments, Tim. With respect to what we call the blue book, which is the review analysis, basically annual review of each judge, each district court judge and appellate court judge in the state court system in Colorado. I think that that blue book is still mailed to every voter prior to an election. And it's got a lot of information in it so that you don't have to do a whole lot of homework to be able to determine whether you are in favor of retaining a particular judge. Really is a very useful tool there. The other thing is that Tim mentioned the judicial selection commissions, and they are made up of not only lawyers, they are made up of lay people like you, although some of you may be lawyers too. You can apply to be a member of a judicial selection commission. And if you are interested in doing that, please Google Judicial Selection Commission, Colorado. And immediately you will get information from the state government with respect to how the commissions work and how to apply to be a member of those commissions. It could be something that really is informative to you and that you find is extremely valuable in terms of participating in a system to assure that we truly have an impartial judiciary in the state of Colorado.
Thanks, Mary. That's great. There's also citizens can also join the judicial the review commissions to both lawyers and non-lawyers, and you don't have to actively be in front of a particular court to serve on the Judicial Review Commission, because the tasks that people do is they go out and send surveys to litigants, they send surveys to lawyers, and gather information about the behavior, conduct of each and every judge across our state. So that's a second way that folks like you, to the extent you are interested, could get involved in the system. So that's this is a slide of the leadership of the National Association of Women Judges, the Informed Voters, Fair Judges Project. You can connect with them on Facebook and InstaFace and all the other things that the young kids are doing these days. And this is the leadership of the American College of Trial Lawyers effort that Mary and I are involved with. And this is the end of our presentation. I think we may be out of time, but if not, we're certainly happy to answer any questions.
All right, I think we can have some questions. I know Sally has, and Sally looks like one. And if you stop screen sharing and we can see everybody, there we go. Sally? You there, Sally?
I think you're still on mute.
Sorry. A speedy trial, is that required federally or statewide? And what happens when there is not one?
Did you say jury trial?
Speedy trial.
Speedy, fast.
So yes, it's a element of the federal Constitution. So it is required. Speedy trial is required in both federal and state criminal prosecutions. Neither Mary or I are criminal lawyers, but my friends who are criminal lawyers, either prosecutors or defense lawyers, say that that COVID has thrown things absolutely into a lurch on the speedy trial front because of the inability over the last 18 months to hold trials. And largely judges have, I think, ruled that the pandemic essentially excuses the speedy trial. I don't know the ins and outs of it, but I do know that it has been an issue in the criminal courts over the last 18 months. I don't know if you have anything else to add, Mary.
No, not really, but I think in fact, some defendants have even agreed to a tolling of the speedy trial rule. But And I think you're right on with respect to judges deciding that because of the inability to try cases, they are going to extend the provisions that would otherwise be imposed by speedy trial rules.
And I will add one other thing, Sally, is that it only applies in criminal cases. So in civil cases, there is no such thing as a speedy trial requirement. And just by way of example, I have had cases that have lasted in excess of 20 years in the court system. And I won't bore you with the war stories, but I have had cases that go on and on and on and on. So the civil court system, unfortunately, does not have a speedy trial requirement.
Okay.
Thank you.
Any other questions?
I have a question.
Ned?
Yes, I wonder if you, either one of you would like to address just the overall issue of judicial activism. I think you put up the slide about the resistance to, or the effort to limit some judges' powers in the past, and I think it's tied to some of that. I just wondered if you'd address that and give us your point of view.
My thoughts on that really are that the term judicial activism is used generally by someone who doesn't like what a judge has just done and believes that the judge has extended the law in some way that is not in keeping with the Constitution or the statutes which are applicable. And I think in terms of any concept of judicial activism, judges are supposed to apply the law to the facts. Judges don't make law, they interpret law and apply it to facts in the cases before them. Now, some people would argue that if you look at what we think of as common law, that is law that is developed through cases, that judges are extending things beyond where they should go. But in many respects, I think the concept of judicial activism really is sort of a political attack by people who are unhappy with what a judge has just done. Tim may have other thoughts on that.
Nope, I was going to say it's in the eye of the beholder.
Yeah.
Well, I have a question that I didn't realize, I didn't know until I heard your presentation, and it probably is fostered because there's a retired lawyer who was with the Air Force and I know could argue cases before the Supreme Court on this meeting. So I realized while you were, and this was an excellent presentation, by the way, I just want to say that, that was amazing. But what is the role of lawyers and people who are serving in our military? How does that fit in with all of the things you're talking about and, you know, cases that result while people are in the military?
Well, there is a military justice system, which is outside of what we have been talking about today. And I have to tell you that I am not particularly familiar with the military justice system, but it does handle many disputes, whether they're criminal and sometimes civil or disciplinary, related to people who are in the military. And it is the military who is conducting those trials by way of a tribunal or appointed judges or things of that sort. And Tim, you may know more about it and can add something here.
Sure. Yeah, I have some experience. So as Mary said, you know, we talked about a parallel court system, a state court system, and a federal court system. And of course, it's more complicated than that because, you know, there are other parallel branches or parallel lines. And as Mary said, one of is the military justice system. And so for people who are in the military, they can have trials within the military court system that are outside our state court system and our federal court system. And so those are handled by military lawyers, both on the prosecution side and the defense side. There's also a civil system. And I've been involved a little bit on some criminal matters in the military justice system, but also on the civil system. So I and my firm have represented veterans who are who get maybe an adverse decision on their health benefits. So a lot of the folks who've come back from Iraq and Afghanistan and who might live down in the Springs or one of the Air Force bases or other bases around the state have had traumatic brain injuries. That's been a very controversial issue over the last 20 years. And they may be unable to work or unable to work completely, but the military didn't treat them as disabled and didn't give them the kind of benefits that we thought they were entitled to under the law. And so you go through a civil appeals process in the military in which, again, it's a parallel. It's not in the state court system. It's not in the federal system. It's within the military's own administrative process. And at the end of that line, you can actually then take it to federal court in certain instances. And we've done a lot of those over the years where we've been unhappy with the treatment of a veteran and through the administrative process, through the military, through the various levels of appeal. And then you can take that and go to federal court. So I don't know if that answers your question, but.
So I'm thinking, Fletcher and Lori, that we need to have a follow-up presentation by Tish Taylor.
Yeah. Good idea.
Yes, and I know you want to give me more work.
Well, Tish, I didn't realize I didn't understand some of this. So we either have to go out for coffee or because I mean, as he said, I have other questions. Or I think it would be
Or
great.
beers, whichever.
I think it would be great to follow it up with a presentation since, you know, they have just talked about it being related but different. I don't know if it's separate but equal, but yeah.
Okay. Well, Tim and Mary, thank you so much for a presentation. It was excellent and I learned a lot and I hope everybody else did too. Good.
We really thank you for your interest and your time today. It's been a pleasure.
Absolutely. Thank you all.
Okay, let me stop the